Oh, yes. Just reading this, right? Hanover Bank, a trust company. The right to be heard has little reality or worth unless one is informed that the matter affecting one's property rights, custody rights, or personal rights, constitutional rights, victims' rights, humanitarian rights, or civil liberties is pending. Pooch, and can choose for him or herself whether to appear, yes, or default, acquiesce, or contest. Now I know in reality, right? If I don't get notice, it violates rights. Now, small versus the United States, an elementary and fundamental requirement of the process in any proceeding, which is accorded finality, is notice reasonably calculated under all circumstances, yes, to apprise interested parties of the pendency of the action and afford them an opportunity to present their objections. Yes. They have quite a bit of case law in here for these rights to notice. To be effective, notice must be sufficiently given in advance of a proceeding to give the crime victim the opportunity to arrange his or her affairs in order to be able to attend that proceeding, and any scheduling or proceeding should take into account the victim's schedule to facilitate effective notice. Yes, yes, yes. Effective notice. Now I know when the judge requests my presence in court 2 judicial days. I don't think that's accurate, timely, or effective notice. Yes. Now you would say, well, I'm homeless. I have nothing to do. I would say that it takes a little time for me to arrange my affairs in order to attend any court hearing, any proceeding, where I'm named as the defendant. Yes. Now you said, well, we don't have to give you notice. I would say that case law supports that even as the defendant, yes, that you do have to give me notice, because I have to have effective notice in order to be able to attend that proceeding. And any scheduling of proceedings that should take into account the defendant's schedule to facilitate effective notice. Yes. Now, I kept telling you about this 5 judicial days. Pooch, I gave you the actual instructions on how to issue protection orders. Yes. And you said that as a homeless man, that I don't have any rights. Pooh. But I noticed that the Senate reports note that reasonable must be judged by the circumstances of an individual case. Yes. Thus, while mailing a letter would be reasonable notice of an upcoming parole release date, it would not be reasonable notice of the escape of a dangerous prisoner bent on taking revenge on his accuser. Yes. Yes, yes. Now, I know, Pooch. We're talking about a dissolution of marriage. Oh, you said, well, she mailed it to him and he didn't get it, or he did. He's just not contesting the dissolution of marriage. I would say that was an effective notice. Oh, wow! Now, I know, if you think of, as a victim, well, we'll send you a letter that the escaped individual is out to get you, and we're not going to have proof of service. No, you're sitting there as a victim. Pouch! Now, I'm thinking, yes, I know that right now. Pow, 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 pow. They made it specifically clear, yes, that the escaped accused, escaped from prison, is out to get you, and the state thought it was reasonable notice to send a letter, yes, some sort of mailing, yes, to the wrong address that you hadn't had for the last fucking 5 fucking years.